Today on the Sonny Chung podcast, we thrilled to welcome attorney Kendall Laughlin, raised in Fort Smith, Arkansas. Kendall began his journey by earning an accounting degree from University of Arkansas before pursuing a law degree at SMU. His career has been deeply rooted in both real estate and law. Began as a licensed real estate agent during his summer in college, and later become a CEO of real estate rental business with 31 offices. His expertise in commercial leasing grew from this foundation, and over the years, Kendall has served as a legal counsel for business such as T-Mobile distributor, which expand from 25 to 300 store, and an Asian grocery store chains that grew from 3 to 13 locations. Today, Kendall join us to share his insight in the world of commercial leasing agreement, tenant right, and his professional evolution. Dive into the conversation with Kendall today. Thank you, Kendall, to be on Sonny Show. Is there anything else you would like to share with our audience today?
Well, I think what comes with the years of experience is the opportunity to share with a client not only what they're trying to have from a legal perspective, but also the business experience that I've had with the variety of clients. So each of my consultations includes some both law and business experience. For example, I just got off the phone call trying to work out a piece of property and where the water lines and waste lines are so that we don't buy a piece of property that's not developable.
Right. That's very important. Sometimes developer overseen that, but if you have your expertise in law and real estate as a background, that do help. So let's dive deep into a high level of who you are and how you come about be an attorney at law and also in the real estate industry. How can you share with us, how did your early experience working in real estate during college summer influence your approach to law and real estate management later on?
Yes, Sonny, thank you. My first year of college, started accounting classes. And then that summer, I worked for a real estate company putting out signs. And I actually had one closing that summer because I'd taken the Arkansas real estate required classes so that I could be an agent. So with that, I just got real estate in my blood. Then from throughout my earlier years, which would be junior high and high school, I was coming to Dallas on a regular basis. My family was in real estate here in the Dallas area. So in the summers, I would also work around the family businesses, whether it was multifamily or property management. Sometimes I'd work with property management crews. Then in law school in the summers, I'd also work in the rental leasing office in those environments. So really just real estate got in my blood.
Okay. Well, that how you transition, become a CEO at rental business, managed over 31 business?
My father started an industry called apartment locating in 1959. The company is called Apartment Selector. So after I'd been practicing law 5 years, my stepmother, who had inherited the business from my father, called me one day and said, with your business and legal background, we'd like to sell you the business. At that time, there were about 22 stores. And between the first 5 or 6 years, we grew it up to over 30 stores. And that's having real estate agents that focused on apartment leasing and locating. So during that time, I was signing commercial leases using my law background. We were also into franchising. So I was using my law background to draft the franchise agreements and the types of relationships you needed to have between landlords and tenants, which is something we did every day.
Interesting. So when you do dual roles as a lawyer and as a real estate professional throughout your career, what challenge did you face and how did you overcome them?
Well, the real challenge was that when you're a lawyer, you have this one-on-one relationship, much like a broker does. When you become a CEO, you have 100, we got up to 150 real estate agents. And so the relationship of management, delegating, working, training, building teams, those kinds of relationships are very important to an organization. And thus, the clients that I have that have the same situational growth, I'm used to being able to explain to them and give them some expectations of where in 3 to 5 years, how their business will grow in helping them look at their legal needs, but also their business needs in that growth pattern.
I see. I mean, that really be a helpful to attend and any client that you're working with just real estate background. So let's dive deep into your profession about lease agreement. When you like as a real estate agent, sometimes we don't have the right or we cannot practice law. That's why we have someone, attorney at law like you, to review all these and make sure is fair on both sides, and balancing the legal expertise with the client expectation can be tough, right?
So they're in North Texas, for example, they're really two major organizations that have standard pre-printed agreements that real estate professionals like yourself are able to use and work with the templates. I think it's basically all online now. So you have NATCAR, the North Texas Commercial Real Estate Group, and then you have the Board of Realtors that has commercial transaction documents also. So those are quite often used and fit maybe 80 to 90% of the time the needs of a client. But what you find out is that there's always some exceptions, some little peculiarities that each client has because each client's unique. And at that point, when you start drafting paragraphs or changing documents, under Texas law, that requires an attorney. And quite often I'm working with realtors such as yourself in helping them maybe add a one-page addendum to their agreement that touches on these issues that need a better understanding or better communication. And then sometimes we're drafting documents from start. So whether it's a commercial lease or a purchase agreement, you have both choices. You can use a pre-printed form and modify them, or use basically all attorney drawn up documents.
Well, as you know, sometimes as a landlord, they do not use the standard form at the Texas, which they have, the NATCAR or Board of Realtor. Usually they have their own lease form that's been drafted by their own attorney. When most of that case, tenant actually hire you to review the lease. What those things on those leases that kind of help protect the tenant, and what should they look
Okay,
for?
so I'll explain the process and integrate your question.
Love it.
The process basically is that I will get the lease with the letter of intent. Then I'm going to compare the lease that's drawn by the landlord or the landlord's attorney, and I'm going to make sure all of the items that you all have pre-negotiated are in that document. Then I'm going to take that document and preferably in a Word format so that I can use the red line feature that Word has, and I can go in and start customizing the document. In written agreements, there's basically three major categories that each side is concerned with: rights, duties, and liabilities. So when I read the document from the tenant's viewpoint, and that's about 80 to 90% of my work on leases is assisting commercial tenants, I want to look at the rights of the landlord and the rights of the tenant, the duties of the tenant, the duties of the landlord, the liabilities of the tenant, and the liabilities of the landlord. And so, not to be surprising, one duty would be to pay rent. Well, I would like to make sure that the tenant has a written notice if they've not paid the rent before the landlord would put them in default. In terms of liabilities, leases in the North Texas area tend to be what's referred to as a triple net lease. And that means the tenant pays a base rent plus common area expenses, plus insurance that the landlord carries, plus taxes on the property. It's very difficult in today's marketplace with taxes changing as rapidly as they do to have landlords enter into gross leases where the landlord is responsible for insurance and taxes. So I take the landlord's lease, for example, where the common area expenses are, and I want to make sure that those expenses pertain to my client's needs and not overly broad. One area would be the amount of management fee the owner's trying to collect, whether or not they're also marking up the expenses with what's referred to as an administrative fee. So those would be some of the areas on their liabilities I'm trying to assist. Another area is who is responsible for the plumbing lines that leave the premises for a commercial lease. I'm concerned that outside the premises, that line could have been there for years, and I don't want my client to have the liability of repairing plumbing lines outside the premises. In North Dallas, a few years ago, there was a tornado that went across the Royal and Forest Lane area. And so there were businesses that had their utilities interrupted for months and months. So I would look in the lease and try to reword and balance the interruption of utilities aspect. Another very important aspect, because I've done so much business law as well as landlord-tenant law and worked in franchising, I'm very concerned about a tenant's exit strategy, which would come up this way. There's an agreement, if you sign it, with each landlord about assigning or subletting your space. I'm concerned that my client have a reasonable opportunity to sell their business, or if the business is not meeting their needs, to be able to sublease the space to another tenant. And so that would be one of the rights I would want to give my client in that rights, duties, and liability balance. Those are some of the major types of topics I'm looking into.
I think anybody about to sign commercial lease either hire you or any attorney of their choice, but I would highly recommend, because of your background in law, of course, and then your background in real estate, is to add value proposition to anybody just starting on business. There's a question that jumped out to me that I wanted to ask you. How can the tenant protect themselves from unexpected rent increase due to lease term with the hidden costs and everything else?
Well, okay, let's talk about rent and what typically is referred to as additional rent. Your rent would be typically referred to more specifically as base rent. And you should have a chart in your lease. And so you're going to know each year, each month, of what your base rent would be. Let's say it's based on $30 a foot. You have 1,000 feet. That's $3,000, right?
Correct.
Or whatever the math puts out there. And then you have common area expenses, insurance, and taxes. That's the triple nets. So oftentimes in the common area expenses, the landlord and tenant through negotiation agree that the landlord's annual increase in common area expenses that he controls would be set at, let's say, 5% or 6%. So the tenant can basically know when they go into a lease, if their common area expenses, let's say, is $100 a month this year, next year it would not be more than $105 a month. And thereafter in the lease, that cap would apply. It's very difficult, as I mentioned, to get insurance caps or caps on property taxes. Particularly, one of the things that to be aware of when you sign a lease, you're making a balancing decision between base rent and triple nets. So it's very wise to try to be sure the landlord has a very thorough expense chart that you can review to use with the realtor to determine that those expenses that they're estimating are actually pretty close to accurate. In other words, if a property is recently purchased, for example, it's mid-year, the property sells, this year the taxes will probably still be similar to the year before. But next year, with a new owner, the property district is going to reevaluate those taxes. And in Texas, nothing is going to apply to the previous history that the taxing board, the appraisal board, they can go in and reevaluate. So you might have been told your taxes were $8 a foot, but if that property was in a particularly growing area and whatnot, the taxing authority next year might say $10 a foot. That $2 a foot would be a surprise to you, but it's very difficult to cap. So analyzing the expenses is very important going into the lease.
And usually that's the real estate agent able to assist the tenant with that, make sure all the costs to semi-accurate and put a potential cap on it. And most of the time the landlord doesn't want to do that. Is that when you come in to renegotiate in a sense, or what's your duty when that happens?
Well, once the lease is executed, it's very hard to get in renegotiating the rent. Yep. To a tenant, a commercial lease is a business document. They're trying to predict their costs so they can go run their business and determine their profits. To a landlord, a commercial lease is more of a financial document. They take that lease and go to their lender or their investors, and they say, this lease will pay us, say, $30,000 a year. So either we want to borrow against it or we want you to invest based on that return. And that's the reason it's difficult to renegotiate, because quite often the landlord has made obligations using your lease. Absolutely. And you'll find in that lease that quite often they want annual financial statements and whatnot to give the lender or their investors to help them substantiate that property is carrying the value they promised to their side of the equation. In some ways, it's very complex. I try to simplify it, but there's a lot of variables.
It is. And thank you for sharing the information from real estate investor standpoint and from the tenant standpoint, as a financial paper for the investor, and for the tenant, it's more a business paperwork, right?
Yep.
Let's say worst case scenario that the tenant signed the lease, right? And all the thing that we can negotiate, everything is done. And if the tenant want to sublease or assign their lease to another party, there's a clause in there. And is there any way that how can the tenant protect themselves from the landlord that?
Well, okay. I'll adjust this question and address it in a couple of ways. First, in the lease, there will be a clause that says the landlord and the tenant agree the tenant cannot sublease or assign. So that would be a default under the lease. And there's one important aspect to all this that we will finish on about guarantee agreements. Okay. We haven't touched on the personal obligation of tenant, but I'll get to that when you and I are ready. The second thing is there oftentimes is a clause that says the landlord will not unreasonably hinder, delay, or deny an assignment or a sublease. So there's some softening of the language, but what you try to build into the lease, there's some standards so that we can judge what is reasonable for a landlord. For example, if the tenant had a net worth of $250,000 and the landlord accepted that $250,000 is the tenant's net worth, then you would add into the lease that I could assign or sublease the space as long as the new tenant had $250,000 of net worth. There are a number of little alternative items like that. Another one might be, let's take the nail salon industry, that the new owners have 3 years or more experience or operate 2 or more stores. Or if it's a franchise business, that the franchisor has approved and trained the new team that's going in there as the franchisee, then those would be some setups that later, when the tenant has the interest or the need to change the ownership, they have already pre-negotiated. So it's not a real delay, because even that sometimes takes 2 weeks or a month. And when you have a buyer that's wanting to take over the business, they don't want to wait 6 months.
No.
And so you try to add some exit strategy into this process.
That's a good way to put in content, how to help protect the tenant. There's something that is very interesting on this. I want you to share after we negotiate this, and one question I have a lot is the future value of the lease. Usually, how can a tenant ensure they have the right to renew their leases, and what should be negotiated in the renewal option? Okay,
so the lease environment, I see several choices. One choice is you have a 5-year lease and another 5-year together, so it's a 10-year lease. And so the first 5 years we negotiate what the rent will be, and then after 5 years we negotiate how much it may increase, say $1 a foot. Other leases, and I see this fairly regularly, they start with the first year and it goes up 2% a year, let's say.
Yeah.
So that's
more.
Another an approach. The third approach that is somewhat difficult, I think, for all the parties, is that the first 5 years you would have the fixed rate, your base rates identified, say $30 a foot. Then it might use the terms fair market rent or market rate for that second term. That leads to a lot of confusion. Once again, if I'm looking at it from the business side, very hard to budget, because I could be in an area today that's I office in the design district. And if you went back 8 years ago, the design district was kind of in a less active, and now it's gotten real active. So just in the last few years, the rents have really increased in this part of town. And if I had one of those variable clauses, my landlord would be able to come in and say, well, you were paying 30, but now the market rate for new leases is 40. So you as a tenant have invested your money to open the business. And now 5 years later, the landlord is trying to up the rent based on the fair market value. So I try to put a cap that it wouldn't be more than, let's say, 8 to 10%. That would be a strategy. So each of these duties and rights and liabilities, I have a strategy to try to balance it and have predictability into the future. Okay. Now, you know, all I can do is try to present them to the landlord, present the logical arguments, the business arguments from the tenant side, and you try to have both parties realize that success is valuable to both parties. Now, the last thing that comes up, because it comes back up, typically each business for each location uses in Texas a separate limited liability company. They're referred to as LLCs. and it's usually a single use. And so if they have 3 locations, they would have 3 LLCs. So the landlords know this. Once again, they see this as a financial instrument, and they see that an LLC distributes all its profits every year. So an LLC doesn't build up a balance sheet. So the landlords want, and get in almost all the cases, a guarantor to come in and say, if you don't pay the bills and the company doesn't have any money, we get to come to you personally, and you have a personal obligation. Yes, you have an LLC, and if for some reason you had an employee or a customer slip and fall, you have insurance and you have your LLC protection. But to my obligation, i.e. the landlord obligation, I want you to personally guarantee that obligation, because I don't want you leaving in the middle of the night and leaving me with the no rent income and maybe having to clean out your space. And I want that predictability. So they try to get guarantees. Now, this is, once again, back to the rights, duties, and liabilities. Oftentimes what we're able to do is to look at how much tenant finish out was given to the client. Let's assume you get a $30 lease, you get $30 for tenant finish out. And so you would amortize that over the 5 years, let's say.
Mm-hmm.
And you take the real estate commission, you amortize that over 5 years. So if you stayed 2.5 years and left, the guarantor would owe half of the tenant finish out back and half of the commission.
Right.
That's not an uncommon approach. Another approach is that after 3 years and you've worked your business, we'll only hold the tenant guarantor responsible for 1 year rolling forward rents. So if your rent was $3,000 a month and after 3 years, the business was not working, you had to leave, then you would owe $36,000 as a way to buy out or terminate the lease. Once again, it's an exit strategy, just like selling your business is an exit strategy. Realizing that some businesses struggle and planning for that struggle with an exit strategy is also valuable to the tenant. Once you have a business that kind of is going downhill and very stressful, it's even more stressful when the landlord's calling you wanting rent. Now, in Texas, in many states, the landlord has an obligation to mitigate the damages if you have to go into default, which means basically go release the space. But this gets very expensive in litigation. It's kind of a complicated process. So if you can, once again, have some predictability in what your obligation would be if you had to move, it's worth trying to spend an hour or two negotiating.
Right. And from tenant perspective, not all landlord willing to do 1 year or usually the landlord ask for the whole term of the lease. And you did give some really good strategy for the tenant to be exit out the lease if the business is not go well. What the success rate do you see when the tenant renegotiate or negotiate those kind of terms?
A brand new tenant that's never operated a business before, maybe they're a franchisee, their franchisor will have those rights to take over the lease.
Mm-hmm.
The new tenant, it's going to be much more difficult. Maybe 20% of the time they accomplish some of these strategies. Someone that's had 3 to 5 locations and they have a track record, and that landlord looks at that track record and realizes they're serious. They have the business acumen to be there. They have personal funds. They'll give them a little more leeway.
Right. So as long as they can see Do you have a business saying?
No guarantee. It takes what they almost call a national credit.
Right.
You know, somebody like the client that I had that had 300 locations. I mean, they weren't going to sign personal guarantees. Sometimes they have to give a corporate guarantee, but they weren't going to sign personal. I mean, the owner was an investor in another state. I mean, he wasn't even actually involved in the management.
So with the corporate guarantee, how does that work?
Well, if you think about, you have an LLC and it's operating that facility, the premises, the corporate guarantee might not actually be the tenant, but it has all of these tenants working under it.
Right.
So when it's a corporate guarantee, it gives that lease a tie into the balance sheet
Of the company.
of the company. Yeah.
Interesting. Very, very interesting. Thank you very much for sharing the information. And I hope, if a new business owner or a seasonal business owner, they can find some value from this conversation that I have with you. Looking back on all your deal that you're working on, what personal value or habit have you credit for keeping you grounded and successful over the span of your career in both law and real estate?
I love what I'm doing.
You love what you're doing?
And so I'm excited about working with entrepreneurs. And oftentimes people will say, well, would you like to invest with us? And I say, no, I'd rather be your advice giver and not have any kind of conflict. But I really enjoy working with entrepreneurs. I've been one myself. And when I can see, I call it a younger person, but it doesn't have to be a young person. It may be someone that doesn't have the business experience. If I can help guide them, like I said, the T-Mobile client I had went from 25 to 300 locations. That was a lot of fun. My Asian Indian grocery store client, when you start getting clients in the 100 million in sales, and I just focus on what I do. I don't try to be a tax expert or an HR expert. I'm focused on the real estate side. I think the enjoyment's creating the value in long-term relationships. I lose a few clients, but not many. It's usually the one major client I can think about had about 20 Hispanic restaurants. I don't speak Spanish. And so they went back to a lawyer that was maybe able to translate a little better. But I've worked with a lot of international folks. And apparently I'm able to kind of work through the integrating their language and our language and kind of my language, kind of working it out without having to be a translator involved. But sometimes I'll have a translator. But I think my flexibility, what is part of what clients like, and kind of this one-on-one that you and I are doing now. This is very typical to my management style, if you will, of the way I work. I'm the lawyer that does the work. I don't learn about the work and have somebody else and having 2 legal fees get involved. If I tell you Thursday at 5, you'll have your contract, you'll have it.
I think that's good. The way that you retain your professionalism and you're passionate about it, you love enjoying helping entrepreneur and help people succeed in business. I think it's good to have any attorney to protect you and at your corner. And I'm glad you work on a couple of my cases, and I appreciate that you are in the tenant corner and try to help protect them. I really appreciate that, Kendall, from the bottom of my heart. So thank you very much for being on the guest today. I think you shared a lot of valuable information. Before we close out this podcast, I do have one last question. I would say the closing question for all the guests that I have on here. So let's say if you achieve all your goals today and you help all your clients that you did, and today's your last day on earth, right? You cannot take your knowledge with you, anything like that at all. What's three most important lesson you would like to share with people, and how you would like your client remember you by?
I'm going to use a couple of isms, they're called.
Okay.
One is the speed of the leader is the speed of the game. Attitude creates altitude. And an old Zig Ziglar, you get out of life what you want by helping others get what they want first.
Love that. I do love that. I think that's great.
My older son put all those, I have about a dozen of them. He put them on a sheet and gave it to me for Christmas. It was very personal, very, very thoughtful of him. But I have those kind of thoughts. You have to guard your garden. If there's any one thing I can recommend to everyone is, you'll have a fence around your garden. You got to keep the rabbits out. You got to fertilize. You got to weed. In other words, whatever your passion is that you're doing, you need to be focused. You need to be sincere about it, authentic. And I think when you do that, your customers know it. My clients, I hope, feel the same way. I call them clients, they're customers. And so if my attitude's good and I'm helping them, then I think that's a good return for them. And so when it's all said and done, if I've done that, I think there will be some people that'll say thank you.
I think a lot of people thank you for your service and your work, and you treat them very well and make sure they protect it as a fair way as you can possible. Well, Kendall, thank you very much to be on Sonny Chung podcast. It's been an honor and a pleasure to have you on here.